In the spring of 2026, a retired British Army warrant officer in his 60s opened a letter at his kitchen table in a county that he does not want named on a YouTube video. The letter was from the Legacy Directorate of the Police Service of Northern Ireland. It informed him that he was being investigated under the inquest reopened pursuant to a 2023 ruling of the European Court of Human Rights. The contact under investigation took place at 7:15 on the evening of the 8th of May 1987, outside a Royal Ulster Constabulary station in a County Armagh village called Loughgall. He had been told, on the day of that contact, that he would never be prosecuted for it. That assurance was made to him in writing by a serving officer of the British Army. The man who signed it has been dead for 14 years. The assurance was not in fact a written agreement in the sense a lawyer would recognise. There was a decision of the Director of Public Prosecutions for Northern Ireland, taken in September 1988, which concluded that the evidence did not warrant the prosecution of any person involved in the shootings at Loughgall. That decision was discretionary. Discretionary decisions can be revisited. In English and Northern Irish law, there is no doctrine of final settlement that protects a soldier in 2026 from a Crown Court the year before he applies for his pension. The letter at the kitchen table is the proof. To understand how the letter arrived, you have to begin at 7:15 on the evening of the 8th of May 1987. A blue Toyota Hi-Ace van drove past the RUC station at Loughgall in County Armagh. Inside the van were 5 men. Behind the van, a JCB digger carried a large explosive charge of roughly 200 kilograms of commercial Semtex packed into an oil drum in the front bucket, fused with 2 40-second detonators. The driver of the JCB was Declan Arthurs. He was 21. Patrick Joseph Kelly commanded the operation. He was 30. Within minutes, 8 members of the IRA's East Tyrone Brigade Active Service Unit aboard those 2 vehicles would be dead. Within that same contact, a 36-year-old civilian named Anthony Hughes, driving home from work with his brother Oliver in a white Citroën, would also be dead. The men who killed them were 24 soldiers of the British Special Air Service. 6 were in plain clothes inside the RUC station. 18 were in uniform, dispersed across 5 concealed positions in the wooded ground around the building. Their codename for the operation was Operation Judy. Their support included the Royal Ulster Constabulary's Headquarters Mobile Support Unit, the surveillance specialists of 14 Intelligence Company, and the RUC Special Branch Covert Section known as E4A. By every account from those who were there, the British state had known of the planned attack at least 10 days in advance and had been watching the East Tyrone Brigade's movements for weeks before that. The intelligence trail went back, by some accounts, to the previous December. The 2 vehicles arrived from the west. The JCB digger had been taken from the Mackle family farm on Lislassley Road, about 2 miles from the village, around 2:30 that afternoon. The blue Hi-Ace had been hijacked in Dungannon a short while before. The attack pattern was not new. It belonged to a method Patrick Kelly had refined over 18 months. In December 1985, the East Tyrone Brigade had destroyed the RUC barracks at Ballygawley with a bomb and shot 2 officers dead. In August 1986, Kelly had hit the Birches barracks at Portadown with a JCB-borne charge of around 200 pounds of explosive, again ramming the bucket through the gate. Both bases had been razed. Both attacks had been described by the historian Mark Urban in his foundational 1992 reconstruction Big Boys Rules as spectaculars. The Loughgall operation was the 3rd in the sequence and the largest in scale. The JCB rolled past the station once. It passed a second time. Then it turned in. What followed was not quiet. Around 600 British rifle and machine gun cases were later recovered from the SAS firing positions. Around 125 rounds struck the van. The IRA team, in turn, expended around 78 rounds in return fire. The bomb in the bucket exploded near the moment the JCB stopped, destroying nearly half of the RUC base. Patrick Kelly was killed at the front of the van. Jim Liner from Monaghan Town, who had spent 5 years in the maze, died in the rear. Padraig McKerney, who had escaped from the H-blocks in 1983, died beside him, carrying a Ruger revolver that had been stolen 4 years earlier at Ballygawley from a reserve RUC officer named William Clement, dead since the previous attack. Declan Arthurs was shot down on the road. He was unarmed at the moment he was hit and was holding a cigarette lighter. Gerard O'Callaghan and Tony Gormley died on or near the digger. Eugene Kelly, the van driver, and the 19-year-old Seamus Donnelly were killed as the SAS swept the contact box. The Hughes brothers had been driving home from a job. They were not part of the operation. They turned into the road from the wrong direction at the wrong time. Anthony Hughes, in the driver's seat, was wearing blue coveralls. The Citroën was hit by approximately 34 rounds from the SAS positions. Anthony was killed. Oliver, the brother in the passenger seat, was struck 14 times and survived. He lived another 23 years and never, in his lifetime, received an apology for his injuries. His widowed sister-in-law, Bridget Hughes, the widow of Anthony, would receive one from the Ministry of Defence in March 2014. The wording the MOD eventually used, after years of refusal, was that her husband had been wholly innocent of any wrongdoing. It was the first time the British state had used the word innocent of a dead man at Loughgall. 3 other IRA scouts in support vehicles posted outside the immediate contact box escaped the ambush altogether. They are still living. Their names are not in this script. The men who fired the rounds were withdrawn that night to Bessbrook Mill, the busy SAS detachment base in South Armagh that handled the regiment's Northern Ireland operations through the second half of Operation Banner. They were debriefed there in the standard sequence: operational, intelligence, legal. The legal element was always the briefest. The rules of engagement that governed their conduct in the province had been issued in a small printed pamphlet known as the Yellow Card, first introduced in 1969 and revised 6 times in the following decade. The Yellow Card had no statutory authority. A soldier who complied with it remained, in the formal legal sense, subject to the ordinary civilian law of Northern Ireland. But the practical understanding inside the regiment, and inside the chain of command that issued the orders, was that the Director of Public Prosecutions would not, absent extraordinary circumstances, pursue indictment of soldiers who had followed a lawful command of arrest and met armed force with force. In September 1988, 16 months after Loughgall, the Director of Public Prosecutions for Northern Ireland confirmed that practical understanding in the specific case. He decided not to prosecute. That decision is the closest thing to the assurance the warrant officer in 2026 remembers receiving. There is no document in any public archive that constitutes a binding amnesty for the soldiers at Loughgall. There is the DPP's letter. There are the debrief records held in restricted MOD files. And there is the long quiet of the years between 1988 and 2001, in which no further action was taken against any soldier who had been at the site. In the language of the time, the matter was closed. Then the architecture changed. It did not change suddenly. It changed in 5 movements over a quarter of a century. And at no point in that quarter of a century did the men who had been at Loughgall vote for any of them. The first movement was the Savile Inquiry, established by Tony Blair in 1998 to re-examine Bloody Sunday. Savile ran for 12 years. It cost the British state on the order of £200 million. Its final report, published on the 15th of June 2010, found that the killings on Bloody Sunday had been unjustified and unjustifiable, and named individual paratroopers as bearing personal responsibility. It was the precedent that proved an inquiry into a single afternoon of Operation Banner could, in principle, identify named British soldiers as the agents of unlawful state killings. Until that report landed, nothing comparable had ever happened. The second movement was 4 judgments handed down by the European Court of Human Rights at Strasbourg on the same day, the 4th of May 2001. The case names are now studied in every postgraduate human rights seminar in the United Kingdom. McCurr v UK, concerning the death of Gervase McCurr at Loughgall in 1982. Jordan v UK, concerning the death of Pierce Jordan in Belfast in 1992. Shanahan v UK and Kelly and others v UK, application number 30054/96, concerning the deaths of Patrick Kelly and 7 others at Loughgall. The judgment in Kelly v UK was unanimous. The court held that the United Kingdom had failed to comply with the procedural obligation imposed by Article 2 of the Convention to conduct an effective investigation into the deaths. The court was careful not to rule that the killings themselves had been unlawful. It ruled only that the investigation into them had been procedurally inadequate. It found the original 1995 inquest at Craigavon Courthouse, at which the family's lawyers had withdrawn on the second of 4 days in protest at the coroner's refusal to share witness statements, was not a sufficient investigation under the Convention. That ruling is the document that quietly began the journey from a closed file in 1988 to a letter at a kitchen table in 2026. What the official record did not show, until much later, was that the same Article 2 procedural obligation applied to dozens of Troubles-era deaths the British state had also considered closed. The 4 May 2001 judgments are, in legal terms, the engine room of the entire modern legacy framework. The third movement was the Inquiries Act 2005. The 2005 Act replaced the Tribunals of Inquiry Evidence Act 1921 and was passed in part because the spiralling cost of Savile had spooked the Treasury. It introduced ministerial control over the terms, scope and publication of public inquiries. The Finucane family, whose own demand for a full public inquiry into the 1989 murder of solicitor Pat Finucane is still unresolved, refused to endorse any inquiry held under the 2005 framework. But the 2005 Act sat in the statute book as the formal mechanism by which a future government could, in principle, order a Savile-style examination of any prior military operation. The fourth movement was the Stormont House Agreement of December 23, 2014. It was a political agreement, not a statute. It proposed a historical investigations unit, an independent commission on information retrieval, and an implementation and reconciliation group. None of the proposals were enacted in the form agreed. The HIU was never established. The Stormont House Agreement did not in itself oblige the United Kingdom to reopen the Loughgall inquest. What it did was hold open, politically, the question of legacy investigations for another decade. Long enough for the next ECHR ruling, the next Article 2 inquest, the next ministerial decision to land. In September 2015, the Advocate General for Northern Ireland, the senior law officer in Belfast, then Jeremy Wright KC, formally directed that new inquests be held into 9 Troubles-era deaths. The Loughgall inquest was one of them. The fifth movement was the Northern Ireland Troubles, Legacy and Reconciliation Act 2023, which received royal assent on the 18th of September 2023 under the previous Conservative government. The Act had 3 principal effects. It established an independent commission for reconciliation and information recovery, to be chaired by the former Lord Chief Justice of Northern Ireland, Sir Declan Morgan KC. It granted conditional immunity from prosecution to anyone, terrorist, security force member or paramilitary, who gave the Commission a truthful account of their conduct. And it closed all outstanding Troubles-era criminal investigations and inquests that had not been concluded by May 1st, 2024. The 2023 Act was the boldest legislative attempt the British state had ever made to draw a single, hard line under the violence of Northern Ireland. It did not survive. Within 4 months of the Commission becoming operational, the Northern Ireland High Court ruled, in February 2024, that the conditional immunity scheme and the civil claims ban were incompatible with Articles 2, 3 and 6 of the European Convention on Human Rights. The Court of Appeal upheld that finding. The Irish government in January 2024 had already filed an interstate application at Strasbourg, registered as Ireland versus United Kingdom number 1859/24, alleging the same incompatibilities. It is the second time in history Ireland has brought an interstate case against the UK. The first was the 1971 case on the interrogation techniques used during internment. That was the position when the Conservative government left office and the present one took over. Sir Keir Starmer's Labour administration was formed on the 5th of July 2024. Hilary Benn was appointed Secretary of State for Northern Ireland. Richard Hermer KC, Baron Hermer of Penillan, was appointed Attorney General, sworn in on the 15th of July, the first holder of that office in over a century not to have served in Parliament before appointment. His prior practice at the Human Rights Bar had included representation of the former Sinn Féin President Gerry Adams in a damages claim, and representation of detainees in claims arising from the British presence in Iraq and Afghanistan. What followed in the months after the new administration took office was a process the audience watching this video has been writing about in the comment sections of British military documentary channels for 2 years. In December 2024, the Northern Ireland Office initiated formal repeal of the 2023 Act. In February 2025, the presiding coroner for legacy inquests in Northern Ireland, Mr. Justice Michael Humphreys, delivered a verdict in a parallel case. The Clonoe ambush on the 16th of February 1992 had been an SAS operation in which 4 IRA members, Patrick Vincent, Peter Clancy, Kevin Barry O'Donnell and Sean O'Farrell, were killed in St Patrick's Roman Catholic Church car park in County Tyrone. Approximately 570 rounds have been fired by the SAS in that engagement. No rounds had been returned. The bodies showed wounds consistent with 3 of the 4 men having been shot in the back while attempting to escape. In February 2025, Mr. Justice Humphreys ruled that the use of lethal force at Clonoe had been unjustified, that the soldiers had not had an honest belief in the necessity of using lethal force, and that the operation had not been planned and controlled in a way to minimize to the greatest extent possible the need to use lethal force. The Ministry of Defence announced on the 23rd of March 2025 that it would apply for judicial review of the Clonoe finding. The next day, the 24th of March 2025, in a separate development, Hilary Benn met representatives of the Loughgall Truth and Justice campaign, a group of family members of the dead. They were legally represented by the Belfast solicitor Dara Mackin of Phoenix Law and by Peter Corrigan. After the meeting, the families confirmed that the Loughgall inquest, which had been formally directed by the Advocate General in 2015 and stalled in the funding queue ever since, would be restored. The sister of Patrick Kelly, Mairead Kelly, told the press, "After today's meeting, we have reassurance that efforts are ongoing to bring back the inquest that was rightfully directed 10 years ago." That single sentence, rightfully directed 10 years ago, is the line the entire current controversy hinges on. Either the families of the men who attacked Loughgall in 1987 have been waiting, lawfully and reasonably, for an effective Article 2 investigation that the UK state has owed them since the 4th of May 2001, and that the British government has now finally agreed to deliver. Or the soldiers who fought back are now, after 38 years, being prosecuted retrospectively under a standard that did not exist when they pulled the trigger, by a government whose Attorney General was, until 18 months before his appointment, a paid advocate for one of the principal political beneficiaries of the operation under investigation. Both of those framings are coherent. The men receiving the letters in 2026 hold the second view, and they hold it with the full backing of the Special Air Service Regimental Association, which by late 2024 had retained the international law firm Sidley Austin to send what was described in the British press as a letter before action to the Northern Ireland office. The letter ran to 7 pages. The former Brexit Secretary, Sir David Davis, described it as unprecedented in the history of the British Army. The substance of the letter has not been published. The reporting describes it as arguing that the Northern Ireland Troubles Bill 2025, in its proposed form, would breach veterans' protections under Article 6 of the ECHR, the right to a fair trial, and under Article 8, the right to private and family life. The Regimental Association went further. It told the Northern Ireland office that the safeguards offered to veterans in the new bill were weak, mostly discretionary, and in almost all cases routinely available anyway. That is a phrase that, read carefully, is a denial that anything in the new legislation amounts to a genuine concession at all. 2 senior figures who have served in the regiment have since spoken publicly in their own names. 1. The retired Regimental Sergeant Major George Sim told the Irish Times in February 2026 that the idea the regiment had played hard and fast with the law was, in his words, nonsense. Is nonsense. He told the same paper that he believed the past was being weaponised by Sinn Féin to win the history of the Troubles. That is one veteran's opinion. He gave it on the record. The first wave of post-2024 cases is now visible in its rough outline. There are the Clonoe soldiers, referred by Mr Justice Humphreys' February 2025 verdict to the Public Prosecution Service for Northern Ireland. There are the Cogue soldiers. The same coroner, in April 2024, ruled their use of force reasonable and proportionate, but their operation not planned and controlled in a way to minimise the need for lethal force, and referred specific named soldiers, including those who destroyed an army video of the operation, to the prosecution service. There is the broader pool of files held by the Police Service of Northern Ireland's Legacy Investigation Branch and by the renamed Legacy Commission, which by June 2025 had a staff of nearly 200, and by September of that year had around 80 active investigations open. The Special Forces Association and the broader Operation Banner veteran community have raised charitable funds to cover legal defence for current investigations. A petition to Parliament demanding statutory protection for Northern Ireland veterans, lodged on the Parliament.uk e-petition platform, exceeded 100,000 signatures and triggered a Westminster Hall debate on the 14th of July 2025. That same day, the 14th of July, hundreds of veterans marched past the cenotaph in Whitehall. The Rolling Thunder motorcycle group had run a comparable demonstration in March 2024. A separate veterans rally was organised through the network of former defence ministers and serving Conservative members of Parliament. The open letter, signed at that point by a group of named senior officers, including former general officers of the Army, was published in October 2024 and explicitly identified the Loughgall inquest as the test case it most feared. Outside Parliament, the political coalition that had once pushed the 2023 Act through the legislature, Conservative Defence and Security MPs, Democratic Unionist members of the Commons, the SAS regimental community, and the bulk of the British military pensioner-aged voter base, has reorganised around the position that the 2023 Act should never have been repealed. The Soldier F case has shadowed the entire process. Soldier F is the pseudonym of a former member of the 1st Battalion, the Parachute Regiment, who was charged with the murders of James Ray and William McKinney and the attempted murders of 5 others on Bloody Sunday, the 30th of January 1972 in Derry. His trial opened at Belfast Crown Court in September 2025. The British state had spent £4.3 million on his defence by the time the trial concluded. On the 23rd of October 2025, the trial judge found him not guilty on all 7 counts. The judge ruled that the only evidence against him, hearsay statements taken from 2 other paratroopers identified as Soldier G and Soldier H, could not be tested as live witness testimony would be, and that the delay between the events of 1972 and the trial of 2025 had so prejudiced the defence's ability to challenge the statements that no reasonable jury could safely convict. The acquittal is, in the strict legal sense, no precedent at all. In the political sense, it is the only test the modern legacy framework has yet conducted, and the test failed. There is a question whether the Loughgall inquest, once it actually begins, will produce a different result. The 2 cases are not symmetrical. Soldier F was a single paratrooper charged in respect of 2 named civilian victims in front of a domestic court. The Loughgall inquest will be a coroner's inquest under the Article 2 standard, presided over likely by Mr. Justice Humphreys, the same judge who delivered Clonoe. Its findings will not produce a criminal conviction. They will produce a verdict on the lawfulness of the use of force. That verdict can then be referred to the Public Prosecution Service for Northern Ireland. The Public Prosecution Service will then decide, as it did in 1988, whether to indict. The members of the SAS team who fought at Loughgall in 1987 do not know, in May 2026, who among them will be named. They know that some of them will be. Then there is the question of the structural asymmetry, the line the Regimental Association has used in private and that has appeared in dozens of audience comments on Historical Note's own videos. The men who attacked Loughgall in 1987 were members of an organisation that decommissioned its weapons in 2005 and whose political wing now holds the office of First Minister at Stormont. The widow of Anthony Hughes settled her civil claim against the Ministry of Defence in 1991 in private for an undisclosed sum. The IRA Members of Parliament, elected to represent the constituencies in which the East Tyrone Brigade operated, benefit from the formal political protection of seats they do not take, but which they cannot lose. The soldiers who killed Patrick Kelly and his 7 comrades have lost their assurance, lost their amnesty, and stand exposed to indictment under a procedural standard that was created by a court they have never appeared before, in cases they were never told they were defendants in. That is the asymmetry. It is not subtle. There is no resolution. The 2025 bill has not become law. The Loughgall inquest has not begun. The retired warrant officer in the county he does not want named is not yet a defendant. He is, at this moment, an interested party. The British state, the state that gave him the order, is now the state that has resumed taking statements about that order. The lawyers retained by the regiment have written in the formal language of the law before action that the state's offer of protection is no protection at all. The Attorney General of the United Kingdom, whose pre-appointment client list included the men who once led the political movement that authorised the attack, has been referred to the Bar Standards Board on a misconduct complaint and has not so far been the subject of any adverse finding. The dead remain dead. The men in their late 60s and early 70s who killed them are not yet defendants. The framework that will decide whether they ever become defendants has been built across 40 years of legal architecture none of them voted for, and most of them, in 1987, could not have predicted. The record is contested. Accounts diverge. The 2011 Historical Inquiries Team review concluded that the SAS were justified in opening fire. The 2025 inquest at Clonaux, on a comparable set of facts, concluded that they were not. Both reviews used different standards of proof. Both were lawful exercises of judicial authority. Both will be cited in the Loughgall hearing. What the Loughgall coroner finds is what the world will read. The British Army warrant officer in the kitchen with the letter is not a fictional composite. He exists. He is one of dozens. The man who promised him in writing that the matter was closed has been dead since the 2nd decade of this century. The men he killed at Loughgall have been dead since 1987. The unit that ordered him there has been disbanded, reformed, retasked. The state that gave him the order is now the state preparing the indictment. There is not yet a judgment. There is not yet a verdict. There is only the letter at the kitchen table and a row of names, both the names of the dead and the names of the living, held in a directorate file in Belfast that someone, somewhere, has decided to reopen.